with us Ashish Joshi. Mr. Joshi is an amazing lawyer. I met this guy a couple of years ago in Philadelphia at the Parental Alienation Study Group, and I got to tell you, impressive doesn't even begin to tell you how good this guy really is. He's an author. He's a top litigator. We're going to learn a lot from him today. Really looking forward to it. Thank you, Ashish, for making time for me today. I'm so glad you're here.
Pleasure.
So the
Thank
world
you, Dave,
of,
for
I'm sorry?
Thank you for having me.
Oh, my pleasure. My pleasure. It's great to have you. The world of parental alienation is so complex and people have so many misconceptions about it. Can we just start by describing what it is and really its impact on the children?
Sure. So the term parental alienation has been described by mental health experts and courts in various different ways. But at the heart of the matter, the courts see parental alienation as a phenomenon that occurs after divorce or separation, when one child is aligned with a parent for no legitimate justification. And there's also presence of alienating behaviors. So it's a mental condition that the courts see where the children or the child suffers from severe polarization or delusionary thinking or negative impressions about a parent. And the targeted parent or the rejected parent has not done anything to deserve that. It's important that we realize that we are not asking the targeted parent to be perfect. No parent is perfect. But the key in alienation cases is that the child's rejection of the parent or the child's rejection of the relationship with the parent is disproportionate. And that's the key.
So that's
you also asked about the harms to the children. I mean, there's a lot of research that demonstrates short-term and long-term harms that children suffer, and even the targeted parents. I mean, case of severe parental alienation is child abuse. And there are a lot of cases out there that have called alienation as emotional abuse, psychological abuse. And it's not that just children. It's also important to realize that parents who are being rejected or targeted parents also undergo trauma. And it's extremely painful to go through parental alienation because your flesh and blood is rejecting you. And these parents, their children are alive. They are physically alive, but they feel inaccessible. They are dead to them. Right. The child that you know, the child that you used to know is somehow just not there. And it's incredibly stressful and painful situation to be in.
So there's so many things that come out of this. You said at one point, like in the extreme cases of parental alienation, it's mental abuse and emotional abuse. What are the other, what are the non-extreme cases? How do we grade these cases? How do we decide what's going to really be an extreme case? Because the term gets thrown around an awful lot by litigants.
Right.
And so I think if we can kind of explore, what does it really mean in the shades of it, that'd be really helpful.
Sure. So the mental health experts look at parental alienation as a spectrum. On the one hand, we have mild cases where the children are starting to voice complaints. They're starting to somehow rebel against visitation. They are making excuses to not see a parent, or when they do see a parent, they always have some complaints or other. But overall, the relationship is still okay. You have kids going to see the parent does engage with the kid engages with the parent, but there are some red flags. And then there's a moderate situation where visitations are being missed. The children are more vocal, they are more defiant, they are disrespectful, there's rudeness, there's some oppositional behavior as well, refusing to eat together, have any activities together, telling the parent not to show up for my soccer activities, don't show up for my school, I feel embarrassed if you are there, or not responding to text messages, not giving you a call back. And then on the extreme side of the spectrum, we see severe parental alienation, where the child's behavior is pathological, where you see the child just going into almost a seizure when they see a parent. They start shrieking and screaming for help. They just curl into a fetal position as if they are suffering a shock by just being around that parent. They have all these theories about how the parent is going to kill them, and they're going to kill themselves before they see a parent. They start cutting, eating disorders. So a lot of those behaviors come across as well. So it's a spectrum. And it's important to realize that if you are fortunate to be on the mild side of the spectrum, it doesn't mean that you sit back and you can relax. It means that you have been given an opportunity to address this problem and nip it in the bud. And that's where you go in and you double down in your efforts to educate the court and your lawyers as to what's going on, because you damn well don't want to be in a situation on the other side, because that is just pathological, and many, many, many courts refuse to intervene at that point in time or simply don't get it.
Sure. And so, we've got two questions here. It's like, who does this alienating behavior? Like, what's driving their desire to cause the schism between the parent and the child is one thing I want to talk about. And then at some point, we're going to talk about, how do litigants actually educate their lawyers and the court about this? So let's start with, like, who am I opposing? If I'm a targeted parent, what's my alienator like? How do I describe them? Who am I looking for?
Well, they come in all shapes and sizes and all sorts of people. I mean, sometimes we have undiagnosed personality disorder issues with someone. Sometimes it's just sheer hatred and venom and hostility. Sometimes the behaviors have been present for a long time, but the children were not reacting to it. And all of a sudden, you see children being vulnerable and finally succumbing to these behaviors. So, in my opinion, there's nothing such as unintentional alienation. There are some people who say that, well, the behaviors were bad or the behaviors were indeed alienating. However, mom or dad didn't really mean to do that. Right. And I think that's an absolutely bogus argument. You don't say someone who abuses a child, whether that person intended to abuse a child or not. Either it's child abuse or it's not. And research demonstrates that intentional or unintentional, the behaviors have the same effect on the children. So it's hard to say, why do people engage in these behaviors? It's pathological, no doubt about it. It's severely harmful. And there's an argument that most of the alienators, most of the people who engage in this severe alienating behaviors, if they undergo a proper psychological evaluation, or if they undergo a proper forensic evaluations, there probably will be some evidence of severe traits of narcissism, severe traits of histrionic personality disorder, perhaps bipolar concerns as well. And at the end of the day, we have evidence of boundary violation. Alienation is a situation where there is no boundary between the parent and the child. And the healthy boundary, the normal boundaries of adult-child relationship is often violated. And the parent just starts seeing the child as an ally, as a confidant, as a buddy. It's us against him or her. It's us against dad or us against mom. And those healthy boundaries which maintain the parent-child distance and relationship are violated. So the child is either infantilized, or the child is being parentified or adultified. And that's when you see the effects of alienation coming in, where the child starts adopting the view of the parent from the lens of the alienating parent. All of a sudden, the complaints that are being made by the alienating parent against the rejected parent are being parroted by the child as well. And you see some ludicrous situations where the kid says, well, yeah, I remember dad was always drunk. I remember I was 2 years old and he came home stumbling drunk. I remember that. I have it written down somewhere in the house. And it's just mind-boggling, where you have a wonderful, normative, healthy relationship between the child and the now rejected parent. You have evidence of vacations, evidence of parent involvement, and all of a sudden that's all pushed aside. And we are talking back about 8 years ago, 9 years ago, when something alleged happened. And then the targeted parent is just running from the pillar to post, trying to prove it never happened, or it didn't happen in that way. And it's a conundrum.
And that's an interesting element of it, of the chaos that's created where you're trying to always argue against those specific allegations and not get to the real root of the problem. And I think that's one of the things that litigants get trapped in is that whack-a-mole game of, well, yeah, well, okay, so that one didn't happen, but what about this one?
Exactly.
All those false allegations that just become draining. And so what's a litigant supposed to do with that? How do we get past the individual whack-a-moles to get to the root cause?
Well, first you gotta figure out whether you have a case of alienation or not. And one of the problems that I see more and more in my practice is that because the term parental alienation is so prevalent now and is well known, and the courts have started to use that term as well, it's somewhat in the overkill zone.
Mhm.
And you see litigants just walking into the court, filing motions alleging parental alienation at the drop of the hat.
Yeah.
And that most of the times backfires because all you're doing is to desensitize your judge and the court involved professionals about something that might not have occurred in your case. Every bad behavior is not alienating behavior. Every suboptimal parenting decision is not alienating. And even in cases of alienating behaviors, the case may not be of parental alienation. Just because there are some alienating behaviors present in a case doesn't make that case into a case of parental alienation, because you have to connect the dots. You have to show that the bad behaviors or the alienating behaviors have indeed harmed the child or have indeed caused some rupture in the relationship between the child and the rejected parent. So you have to wait and see, but I like to use the 5-factor model. And I recently wrote a book, as you know, David, published by the American Bar Association, Litigating Parental Alienation. I have a copy right here. So I talk about putting a case together. There you go. And let me tell you, I think this took about 3 years into it. And I began writing this originally as an article for a legal journal, basically a hands-to approach for lawyers. And as I kept on writing articles, I ultimately thought I want to put a book together that would be helpful not just to the lawyers who represent targeted parents, but also to someone such as guardian ad litem or children's counsel or a court-appointed parenting coordinator, a judge or a magistrate, because I wanted to give them the science behind the alienation phenomenon without being too jargony about it. But most of all, I wanted to explain how the courts view it, no matter whether you are in Minnesota or Florida or New York or California, wherever. How do the courts view this phenomenon? What have they done about it? What do they look to in terms of evidence when they do make a finding of alienation?
Mhm.
And when they do make a finding of alienation, what do they end up doing? Do they change custody in every case? Do they order mental health intervention? Do they order a particular type of reunification? More importantly, are there consequences? Is there an accountability? Does the alienating parent made to pay the attorney fees and sanctions?
Right.
And I started to put these cases together and I started to look at the common denominators as to what the courts look at. And while there is some difference in some jurisdictions, some are advanced, some are not so advanced, there is no doubt, there is absolutely no doubt that American family courts do acknowledge parental alienation. So when I walk into a case, when the case has been going on for 3 years or more, perhaps, and I talk to a targeted or rejected parent, dad or mom, and I ask them, well, why haven't you gone to the court yet? Why haven't you asked the judge to do something about it? Why haven't you filed a motion for a forensic evaluation or change of custody or something to bring it to the court's attention? The answer, unfortunately, that I get many times is that my lawyer told me that my judge doesn't believe in parental alienation. Or my lawyer told me that no one believes in parental alienation. It's not a scientific theory. Better not mention the term. Agree to some sort of therapy or agree to some sort of lesson parenting time. Don't force the issue. It almost always gets worse.
Yeah.
You give an inch, they will ask for a foot.
Yeah.
You you give up your parenting time, the children get worse. I mean, the worst advice you can give to a targeted parent is to agree to some sort of a cooling off period where you don't see your kids in the hope that they're going to settle down and it's going to be okay. It gets worse in almost every single case. So that's why to to bust a lot of these myths and fallacies, I wrote this book. But to get back to your question, how to prove a case or how to put a case together, like to use the 5-factor model, because when you walk into a court and when the judge hears the kids don't want to see a parent, or the kids are resisting and they are saying we don't want to go, they immediately assume that something must have happened. You know, either the parent is too authoritarian, or the parent is somewhat abusive, or the parent has lacks capacity or empathy and whatnot. And many times the therapists make it worse by aligning with their alienating parent of being triangulated into the dispute. And you often see these motions filed in the court, ex parte, suspension of parenting time, where there's a letter or an affidavit attached from a child's therapist saying, oh, the child appears to be traumatized and it would not be in the child's best interest to go for visitation. Let's have a cooling off period.
Right.
And bam, right there, you are on the defensive. You aren't put in a supervised visitation, you lose your custody, your parenting time, and you keep on going back to the court just to get to where you were.
Right.
But the point that is lost in all of this frivolous battles is, what is at issue here? The issue is not parenting time. The issue is not custody. The issue is not the lost time. The issue is the child's mental and emotional well-being. And that's how I like to frame it for the court. If it's a case of moderate to severe alienation, I walk in and tell the court, Your Honor, we have a situation where the child is at a severe risk of psychological and emotional harm. We have data that shows that if it is a case of alienation, there is no doubt that the child will be subjected to the severe consequences. These are peer-reviewed studies. This is beyond doubt. The only question for you, the judge, the fact finder, is whether it's a case of alienation or not. And I say it is, because look at this evidence. Let's look at the 5 factors. We have evidence of the child rejecting a parent and refusing a relationship. All these phone calls, no answer. All the text messages, no answer. Or sometimes worse, the child is defiant and just flat out tells the parent, don't call me, don't contact me, I don't want to see you.
Right.
There you have evidence. You have factor 2, evidence that there is a healthy baseline relationship here. We are not talking about a parent who has been repeatedly found to be abusive by protective services, or who was a neglectful parent who was never present during the child's growing up, who was an absentee parent. Mm-hmm. We have evidence of a parent who was engaged, who was loving, who took care to be with the child, who was very much involved in day-to-day activities of the child. Factor 3, no finding of abuse against the parent and everything. Factor 4, we have evidence of some of the 17 well-known alienating strategies: repeated interference by the other parent, bad mouthing and campaign of disparagement, withdrawal of love, all the things that and you don't need to show all 17, David. I mean, we only need to show some, not all 17.
Sure.
And finally, we see the signs of alienation in the child. Does the child show any ambivalence in rejecting the parent? Does the child show any, is a child outright cruel to the targeted parent? Is the child using borrowed scenarios? The same complaints were made by the alienating parent or the favorite parent are now being repeated by the child. And it could be anything. My mom's an alcoholic and that's why I don't want to see her, when there is no evidence of someone being alcoholic. Or my dad's abusive, he's mean, he yells at me. Well, let's talk about it. When did that happen? Oh, I don't know, but he always yells. I don't want to talk about it. And the excuses are frivolous. You never get an end of it. And that's where it's important for the judge to hold a hearing to make a decision. What unfortunately happens is that in many situations, The targeted parent attorney files his motion. The favored parent or the alienating parents lawyers respond by saying, oh no, the father or mother is abusive, they deserve this, blah blah blah. Let's ask for a minor's counsel, let's have an investigation. In the meantime, he or she should be on supervised visitation. All the legal professionals usually huddle together, they go back into the chambers or they talk at the bench. There's a give and take. The judge wants everything to be settled amicably without litigation. Little speeches are made from the bench about it's not in your child's best interest to litigate this. Why don't you come back with a resolution? The guardian ad litem who comes on the case immediately tries to be the fixer, because we lawyers like to fix problems,
Right.
So they come in and they say, oh, I know how to do this. I've done this many cases before. Mom, settle down. Dad, you settle down. We're going to have a cooling off period. I know the John, the therapist down the street, who is a great therapist. We're going to go for counseling and it's going to be good. Let's have a review hearing in 6 weeks. And then you go for counseling. And if it's traditional counseling, they are trained to validate the children's fears and complaints and beliefs and all of that without any confrontation. So the child goes in and repeats the same complaints, which have no basis in reality. And the targeted parent is sitting in a room extremely frustrated, not being allowed to challenge those beliefs, not being allowed to say that's not true, not being allowed to say anything to the therapist or the child, but simply to show quote unquote empathy and just to hear the child. And it gets worse and worse. And from 6 weeks later, you come back to the court and it's not working, and the judge is frustrated, and everyone's pointing finger at the targeted parent. It's a complete opposite of what should have happened. So it's important you walk in realizing what's not going to work and somehow don't agree to it. Now, you could still be forced into the situation by the judge, regardless.
Right.
At least then you can go back and tell the judge, I told you it's not going to work. And not only if this is my telling you, we have peer-reviewed literature that tells us that if it's a case of alienation, traditional psychotherapy will not work. And here's why. So there are a lot of things, and this is where it's important to have an attorney or consult with an expert who knows the situation and who have been there before.
Right. As you're going through that, I'm like, okay, that was that case. That's this case. I got that one going on. It's the playbook. It's exactly the playbook that I'm dealing with in a bunch of cases right now, and it's very frustrating. Because one of the other things that I think we need to let people know is that there does come a point of no return. There does come a point where you're done. You're like, the court's not going to do anything at this point. I was in court yesterday on a case where the alienated child is 2 days away from being 17. And we're asking the judge to make orders. And you and I both know the likelihood of a judge ordering a change of custody or anything dramatic at that point when the kid's like, I don't want to talk. I got like a 0.01% chance of them doing anything useful in the long run. And it's hard to tell a parent that listen, we're too late. This needed to happen 3 years ago, 5 years ago when the kid was young.
Right. And that's why the time is of the essence. And unfortunately, there is no right to counsel in a family law setting like you have a counsel at a criminal defense case.
Yeah.
You have a constitutional right to counsel. Unfortunately, you don't have it. Many jurisdictions don't even have legal aid societies or legal aid for these cases.
Sure.
And let's face it, these cases get expensive. Lawyers are expensive. Experts are expensive. Judges don't have enough time on the trial docket for evidentiary hearings. So it's a perfect storm. And the other part of the issue is this sense of complacency or a misguided sense that, if we push for shared parenting, 50-50 parenting in every jurisdiction, somehow this problem would go away. I don't think it's going to go away.
No.
Because alienation often starts in joint custody cases, where each parent has 50-50 custody and parents to begin with. In fact, I think it might even be counterproductive if a state has de facto 50-50 in an alienation case. But regardless of that, I don't think it's a problem that's going to go away. What needs to happen is, first of all, the courts need to start understanding that this is child abuse. When you have a complaint of physical or sexual child abuse, the first thing that you do is to make sure the child is not at risk of continued abuse. You remove the kid. That's what needs to happen in alienation cases. You make sure the child is protected from further abuse, number one. And then you figure out what to do about this. And that means that the people who are in the trenches, the social workers who do these investigations from CPS, Protective Services, need to be trained on alienation. They need to understand what are the signs of an alienated child.
Hmm.
What is the evidence of alienating behaviors? And they need to start making these findings as well. Second, we need to really think hard about quasi-judicial and qualified immunity that we give to people like guardians ad litems. As of today, there is rarely a consequence for a guardian ad litem who is plainly incompetent. If you and I mess up in a case for a client, we have to answer to a malpractice insurer.
At
We
least,
get, we
at
get hauled up.
that, right.
We get hauled up before the Attorney Grievance Commission. We
Yep.
have to answer why we failed to do some things and competently represent our client. If you happen to be appointed as a guardian ad litem or for minors counsel, you are cloaked with immunity. You are answerable to no one. I mean, you get basically you have free checks. That there are no checks and balances, and the judges usually always protect the guardian ad litem. Now, I'm not saying that there are not good people around. There are plenty of cases I've been in where guardians ad litem have done phenomenal work.
Yeah.
They learned the case. They advocated for the child's best interest, not just what the child wanted. They were very helpful in making the court understand why there needed to be separation from the alienating parent and the child. But there are numerous other cases all around the country where these people don't get it.
Right.
And what's worse is that they make no effort to learn it either. Even though they get involved in these cases, there is rarely any effort to go to a CLE program or to read peer-reviewed literature or to bring themselves up to speed to understand what's going on. So there needs to be accountability here. And lastly, there needs to be financial consequences. In some of the best cases I've had where the alienation was nipped in the bud was when the judge, at the very first motion for violation of parenting time, called in the attorneys and the parties and said, we are not going to have this. We don't let the child decide whether to go to parenting time or not. We are going to abide by and follow the court orders. I'm going to order makeup parenting time for the parent who lost out. Next time it happens, I'm going to order twice the number of makeup parenting time. And if it happens again, we might have to revisit the custody because perhaps the other parent would be better at making these decisions. Yeah. And facilitating the relationship, and you get the message.
Can we call a judge? I need about 50 of those judges in LA.
Yeah,
I would give anything to have a judge that had that kind of cojones. So many of our judges, they're just scared to make a ruling that is that strong and definite. I would give anything to have a judge that powerful.
I mean, one of the unfortunate things there are a lot of advantages to Anglo-American system of adversarial justice. Yeah. I mean, it's compared to the rest of the world, we have a lot of good things going for us. However, one of the downside in American system of litigation is that each party pays for his or her attorney. That's a default rule. If you look at some other systems, for example, the English system of justice, the rule is that the loser pays. If I file a lawsuit against you and I lose, I have to pay your attorney fees barring certain circumstances. Here in America, that's not the case. So you see a targeted parent fighting in court for years and years and years and having all this expenditure of attorneys, experts, and everything. And even when they're able to prove alienation, even when they're able to prove that the other party engaged in child abuse, and even when they win custody, rarely they're awarded attorney fees and cost or sanctions. Rarely. Totally. And that needs to happen. I mean, unless we show that bad behaviors will have consequences and there is accountability associated with behavior and actions and omissions, we are not going to see major change here.
I so agree with you. And the biggest problem I have with our system is the only thing that we ever really punish is failure to pay child support.
Right.
Everything else, the judge gives a pass on. You want to
Right.
perjure yourself? That's fine. We don't care. We're not going to worry about that. It's so annoying and frustrating for me as a lawyer, but also for the litigants who are like, why are they allowed to get away with that? And honestly, I hate that question because I don't have any good answers.
Right.
I don't know
We,
what to tell my
we're starting,
client when
we're
they're like,
starting
how are they getting away with that? And I'm like, it's the way the system works. They're just better at working it than you are.
we are starting to see some good law coming out in some jurisdictions. For example, New York, where there are cases which say that in case of alienation, if the child continues to refuse a relationship with the rejected parent, the rejected parent is then off the hook from paying child support
Wow.
to the other parent. There are finally cases where they say, fine, you know what, you won't stop alienating. You can't make your child see the other parent. The child won't have a relationship with the other parent. The other parent has been screaming for help, wants a relationship. Well, guess what? That rejected dad or mom is not just an ATM machine. That rejected parent
Wow.
needs to have a relationship. And if you refuse to have a relationship, guess what? We are not going to make them pay child support. Now, there's controversy about it because there's an argument that child support is for the child and should not be used to punish the other parent. But some judges have said, well, we need some mechanism. We need some
Right.
leverage here because in some cases, it's not possible to change custody. In some situations, the rejected parent is not ready or doesn't want to take custody for many different reasons.
Sure.
You know, if you have a case of severe alienation and you have a child who is physically violent, who has done something crazy in the past, who has threatened to kill himself or herself and done harm, you don't want the child in your house without safeguards.
Right.
But sometimes where
That
people
makes
can
sense.
afford it, and when there is a possibility, the courts have removed the kids and put them in private or therapeutic boarding schools because it was important to get them away from the alienating parent,
Mhm.
even though the rejected parent wasn't quite ready to take the custody and take care of them.
Sure.
But the temporary separation and putting them in a foster home or a therapeutic boarding school allowed the child to be out of that situation and protect them.
That's really interesting.
Right. And or in terms of fathers, you know, if you are a father and you have a severely alienated daughter and you have undergone 2 or 3 investigations where you've been accused of sexual abuse, you're going to be very careful.
Oh, absolutely.
Yeah, you're not going to be rushing into the court asking for custody when you're fighting criminal investigations and all those CPS
No, no
investigations trying
question.
to clear your name. So even in that situation, while you cannot take care of the child yourself or have the child in your home without safeguards,
Right.
it's still important to separate the kid from the alienating parent.
Yeah. I wonder what the intersection here with domestic violence would be. That'd be an interesting. We'll have to discuss that in another episode because in the New York model, where sometimes I could see a parent using the DV claims, which is the ultimate in alienating behavior, and how do you prove that? Because that's such a sticky wicket, as it were.
Yeah,
The
exactly.
DV
I
world
like
is
the
so.
phrase sticky wicket. I love to say sticky wicket. So from India, I'm a big fan of cricket. So there you go.
Well, I'll tell you what, I'll use it more if you could ever explain cricket to me.
I will. That's a conversation or perhaps a tumbler of whiskey or something.
Oh,
But you raise an important point, and I represent women and men who have been target of domestic violence as well. So I've been on the other side. I've been to court to get PPOs, protection orders. I've been there for victims when the abusers have been prosecuted, and I've been in that situation as well. I see alienation as a part of the family abuse wheel. You know, Dr. Harmon and others have written about this.
yeah.
Alienation is simply another form of violence. It's coercive control, it's psychological control, it's basically psychological maltreatment. All those behaviors that we see in severe alienation case are the same behaviors that American Professional Society Against Abuse of Children talks about in psychological maltreatment.
Mm-hmm.
So it's unfortunate that some people have categorized alienation as anti-women or as anti-DV. It's as if that if you acknowledge the existence of the term parental alienation or the existence of the phenomenon of parental alienation, you are somehow negating or taking away something from domestic violence. It
Yeah.
doesn't have to be. It's not a binary equation here. It's not a zero sum game. In fact, they are on the same side and they both are against abuse and abusive behavior. So that's where you also need to educate people more and bring them together because women and men are victims of parental alienation. It's not based on particular gender, the crime. I mean, you have court decisions where men have behaved in a horrible, abusive manner, have been alienating and have
Oh, yeah.
alienated children against their mother. And you have cases where women have engaged in those behaviors as well. So it's a false thing to say that somehow judges change custody and take the kids away from mothers when dads allege alienation. And the allegation that domestic violence are just swiped across and not even looked at. I mean, first of all, I've yet to see a case, an actual case decision where that has happened. I mean, yes, the judges have held people accountable. They
Right.
have held women and men accountable. And when they have found alienation, they have intervened, thank God, as they should. But and in some situation, it's really a tough call because you do have bad behavior. You do have some behavior that could be categorized as domestic violence. And you do have behavior that can be categorized as alienating behaviors as well. And there you have to figure out whether it's a hybrid case. If so, what can we do about it? How do we put this family back together? Do we go for multimodal family intervention? Do we go for one particular set of treatment and then the other set of treatment? And there are cases, for example, the case that came out of Michigan, a published case of Martin versus Martin last year. The case began with a hybrid case where the dad was found to have engaged in abusive behaviors.
Right.
Mom was found to have engaged in alienating behaviors. And 3 or 4 years down the road, dad went to therapy. He changed his approach. He got counseling. He had no relationship with the children in the meantime, but he came back and said, I'm a changed man. I have learned my lesson. I've got counseling. I'm a better man. I would like to see my kids now. And the kids were so entrenched in the past, they just refused to move on. And the mom refused to change her behavior. She continued to alienate. She did not go for counseling. She did not make any attempt to understand how her behaviors were impacting the situation. And ultimately, there was another round of trial. And in the second round of trial, the court found that now it's no longer a hybrid case. It's a case more of alienation.
Wow.
We have a change in the situation where the father changed his approach. He has gone through 3 or 4 years of counseling. He doesn't display any of those past behaviors, but mom has refused to budge. And the judge changed custody.
Wow, that's hopeful.
Yeah, not only the judge changed custody, David, the alienating parent was made to bear consequences. And I believe there was a order throwing her in jail for repeated violation of court orders and contempt.
That never happens.
Yeah,
Oh my God, I have to pull this case and read it.
yeah, it is. And unfortunately, one child aged out, was emancipated from the court system, so couldn't do anything about it. But more and more, we are seeing judges sit back and take notice. What is also heartening to see is that they are getting away from the whole debate about syndrome. 5 years ago, there would be a huge battle about whether it's in DSM-5, alienation syndrome. What did Richard Gardner think about it? Bad things about Richard Gardner and whatnot. And you would just go chasing those ghosts around and waste so much time that it would not be possible to address the situation at hand. Now, thankfully, more and more judges are saying, we are not going to get into it. We
Good.
don't care what label you put onto it. I'm looking at those behaviors. And I don't care what you call those behaviors. I find them to be harmful to the child and the relationship with other parent. I mean, I don't care whether you call it alienation, undermining, counterparenting, overprotective parenting, whatever it is.
Right. Yeah.
So they're getting away with it. And even in some situations where the courts have actually held Daubert or Fry hearings, gatekeeping expert testimony, we have been able to show that expert testimony about alienation passes with flying colors. There is tremendous amount of peer-reviewed research available. There is a tremendous amount of professional literature. There is a wide consensus among mental health and expert community on the effects of alienation. And there are tremendous amount of cases from all around the country that have found alienation.
Hmm.
So I think it's not an issue anymore whether a court believes it or not. I think now the problem seems to be that, okay, everyone is just screaming alienation at the drop of the hat, and you need to be careful about it as well.
And this is where I'm trying to educate men to like scale back on the use of the phrase, because it prejudices the judge against you, as you said earlier,
Right.
when it's the beginning stages of the divorce, and really the behavior is mom saying, dad, you're being a jerk to the kid, and that's not really alienating behavior yet. That's just venting, and that will fade over the next 6 months. And if they start off with going nuclear, they're just going to blow themselves up. You are, as expected, a phenomenal interview. I am so glad we had this opportunity. What's new? What's next for you? What's after the book? Where are we going?
Well, I mean, every day there's a new crisis to fight. Every day there's a new case. I don't see myself as an activist. I see myself more as an advocate for one family, one case at a time.
Hmm.
That's where I can do most of the work and major difference. But I've been getting calls to testify and talk to legislatures, where people want good science, they want good law. I've been also working with people outside of America in various different jurisdictions where they're trying to pass law on shared parenting
Hmm.
or recognizing parental alienation as a part of the statutory definition of abuse, or broadening definitions of domestic violence to include coercive control and some psychological maltreatment behaviors, which would include alienating behaviors as well. Recently, there was a debate before the House of Lords in the UK, and they used some of my research and cases to make a point about it as well. But that's all, as I say, my day job is to walk into the court and
Yeah.
protect the relationship between the targeted parent and the child.
So what I heard was basically you're an international man of mastery.
You're trying to say that. Well, I do have an international background. I grew up in India. I went to law school and I practiced law in India as well before I came to America. I maintained those ties. I've been in many other jurisdictions, mainly British Commonwealth related, so British Virgin Islands,
Sure.
Australia, Canada, UK. But what is remarkable is that these behaviors are the same. That's what is fascinating about the studies done by Dr. Amy Baker, that she studied these behaviors in different geographical and cultural situations. For example, Italy, Scandinavian countries, America, but there is so similarity, consistency in the alienating behaviors and the effects on the child. And that's what we are trying to fight against. I mean, there's a major movement in Japan. In Japan, fathers basically have absolutely
Yeah, that's a whole other
horrible situation.
nightmare. Yeah.
I mean, you go through a court and you are basically a visitor to your child.
Well,
And
their whole philosophy is really interesting. That the easiest way is to just give entire custody to one parent, and the other parent is cut out entirely. I've had
right,
clients who are like, "I think I'm moving to Japan." I'm like, "That's a bad idea. Just don't do that.
yeah.
Bad
I
way."
mean, I mean, despite the good sushi there, they still have downcomes.
Visit you visit. You don't live. All right. So where do people find Litigating Parental Alienation, your latest book?
Right now, the book is available through the American Bar Association website. So if you turn the book around, there's a shop ABA over there.
Okay.
And you can find it if you are an attorney or a legal professional and happen to be a member of the organization, you get some discount as well. Well, and apart from the discount, I mean, I think the ABA offers phenomenal resources. I've been, ever since I came out of the law school and I got the free 1 year membership of the ABA, I have been a member of the section, and I've been extremely involved in the section of litigation. I have been the editor-in-chief of the journal Litigation. I continue to be their publications and content officer. I work with the family law section as well, because I think that's where we can make a major difference to bring this roundtable conferences together from judges in New York, Florida, California, lawyers to talk about the issues, to talk about the problems. And that's how you may eventually make good law, good case decisions, judicial outcomes. So I would encourage people to be members of ABA as well,
Okay.
especially if you are a lawyer who is taking on these cases and you have so much resources at your fingertips there in terms of networking and everything. But I think in a few weeks, the book should also be available on Amazon as well.
Oh,
If not,
nice.
there might be some copies now as well.
Wonderful. And so where do people find you when they're looking for their next lawyer or somebody as an expert to help with their parental alienation case?
My website is the easiest place. It's www.joshiattorneys, plural, joshiattorneys.com.
So that's JOSHI attorneys.com.
Correct.
All right. So, Ashish, we're going to definitely be doing this again because there's just so much more to talk about. I've got so many other questions that you, as the fountain of knowledge, are just ready to answer, and I can't wait to do this again.
Thank you, David. It was a pleasure being here.
All right, Andy. Have a great day.
You too.